Florida Administration Code 6A23.004 Standards of Apprenticeship. The following standards are prescribed for any apprenticeship program. The program must be organized, written by embodying the terms and conditions, employment, training, supervision of one or more apprentices in the apprenticeship occupation is defined in 6A23 Florida Administrative Code subscribed to and by a sponsor who has agreed to carry out the apprenticeship or the training program. The standards must contain the provisions concerning the following: the employment of the training of the apprentice in the a skilled occupation. A term apprenticeship of the individual apprenticeship may be measured either by the completion of the industry standards on the job training, at least 2,000 hours exclusive of the time spent related to instruction, time-based approach, the attainment of the completion, competency-based approach, or the blend of the time based on the blend of time-based and competency-based approach, and the hybrid approach. The hybrid approach measures the individual apprenticeship skill acquisition through a combination of specified minimum number of hours on the job training and successful demonstration of competency described in work process schedule. Determination of the appropriate approach from the program standards is made by the program sponsor, subject to the approval of the department. Determination appropriate of the apprenticeship occupation for the program standards that are to be registered and outline work process in which the apprenticeship will receive supervised work experience training on the job, allocation of approximately time to be spent in each major process. D, the provisions that organize related and supplemental instruction for the technical subject related to the occupation. A minimum of 144 hours for each of the apprenticeship is required. Such instruction must be given in a classroom via electronic media through occupational industrial approved apprentice correspondence courses equivalent value, otherwise forms of self-study approved by the department. Progressive increasing of the scheduled work wage rates to be made or to be paid, an apprenticeship consistent with the skill that acquired with skills shall be expressed in the percentage of the established journey worker hour rate. The rate represents the minimum of each incremental apprenticeship. If the established journey worker hour relates applicable among all participating employers shall be stated in dollars and cents. The entry of the apprenticeship wage shall not be less than 35% of the established journey worker hourly rate paid for all participation employers in the program, provided, however, that no event shall be an apprenticeship wage not less than a minimum wage rate prescribed by the Fair Labor Standards Acts of collective bargaining agreements of the Florida State statute, whichever is higher. No apprenticeship shall receive an hourly wage not less than the percentage of the incremental period in which he is serving applied to the established journeyman work rate. The established journeyman work hourly rate provided by the standards shall be reviewed, adjusted annually in collective bargaining agreement. The minimum hour percentage wage during the last incremental period of the apprenticeship shall be not less than 35% of the established wage rate. The subjection governing apprenticeship program wages shall not be interpreted and constructed in one manner that would cause conflict with applicable federal law regulations. Minimum entry apprenticeship rate, wage rate, and the minimum apprenticeship wage rate during the last incremental period of the apprenticeship shall be reviewed periodically to the department and amended with the determination necessary. F. The periodic review evaluation of the apprenticeship program, the job performance related instruction maintenance of the appropriated progress, the ratio of the apprenticeship of the journeyman consistent with the proper supervision, training, safety, and continuity of the employment applicable provisions and collective bargaining agreements as the ratio not more than one apprentices to participating employer in each apprenticeship occupations. 2 apprentices for every 3 journey workers. Thereafter shall be responsibility for the apprenticeship committee and sponsors ensuring that the allowable rate of the apprenticeship and the journey workers and consistently maintained the program as a whole and each participation employer on the job site. Probational period, reasonable relation of the full apprenticeship term within the full credit of such period toward the completion of the apprenticeship, which cannot be exceeded 25% of the length of the program 1 year, and which is ever shorter. Adequate of the safe equipment, the facilities, training, supervision, safe training, and the apprenticeship on the job related instruction. Required minimum qualification for the person entering the apprenticeship program with eligible starting age to not less than 16 years. The replacement of the apprenticeship under the apprenticeship agreement. The agreement shall directly reference and incorporate with the standards of the program as part of the agreement. Granting advanced standing and core credit for the previous acquired experience and training skills aptitude for the applications equal to the commensurate wages for the accorded progression step. The transfer of the apprenticeship between the apprenticeship program and the apprenticeship must be based on the apprenticeship agreement with the effective apprenticeship committees, and the program sponsors must comply with the following requirements. The transferring apprenticeship must provide the transcript related instruction on the job training of the committee and the program sponsors. 2. The transfer must be in the same occupation. 3. The new apprenticeship agreement agreement must be executed within the transfer occurs between the program sponsors. And for the transfer and participating employers training obligations committee and one exists and is warranted into another participating employer must provide the full credit of the apprenticeship for the satisfactory time and training earned. One, the transferring apprentice must be provided a transcript of the related instruction on the job training by the committee of the program sponsors. The transfer must be in the same occupation. New apprenticeship agreement must be executed within the transfer occupation. Transfer occurs between the program sponsors. The transfer participation employer training obligation committee, if one exists, the warranted or another participation employer must provide the full credit of the apprenticeship satisfactory time and training earned. And assurance of the qualified training personnel. Every apprenticeship instructor must meet the Florida Department of Education requirements for the career technical instruction per section 112-55 Florida State Statute. Subject matter expert individual recognized within the industry having expertise in specific occupation demonstrated by being a journeyman worker or by holding a licensure or certification required for the given occupation. 2. Having training teaching techniques and adult learning styles which may occur before or after an apprenticeship instructor have been started to provide related technical instructions. A recognition of successful completion of the apprenticeship of evidence by an appropriate certificate. Identification of the Department, registration agencies, provision, registration, cancellation, deregistration of the program, requirements of the prompt submission of any modifications and amendment thereto, the provision of registration apprenticeship program, modifications, amendments, notice to the Department of the person who has successfully completed apprenticeship program, notice of the cancellation, suspensions, terminations, apprenticeship agreements, and causes thereof for authority of termination of an apprenticeship agreement during with the probationary period by either party without stated cause. Provision not less than 5 business days, notice of the apprenticeship of his or her participating employer proposed adverse action caused therefore stated opportunity apprenticeship during such a period of corrective action unless so perceptible procedures as are provided by the collective bargaining agreement. Provisions of the guidance procedure, the name, address, and appropriate authority of the program receiving the process making dispositions of the complaints. Recording maintenance of all records concerning the apprenticeship as may be required by the state, federal law, and records must be maintained in not less than 5 years for the date of departure of the completion of their program. Either the participation employer shall sign a participation employer's agreement with the program sponsor accepting the warning formula and all other requirements for the program standards unless otherwise provided for the collective bargaining agreement. The program standards shall notify on the current basis of the participation employer shall notify the department of any changes in status of each of the participating employers which the program sponsor uses the participation employer agreement of the copy of the same cancellation being furnished and the department will satisfy the requirements for the subsection A. W. Within the provisions of the participation employment agreement, employer's agreement, that each participating employer shall sign a participation employer agreement with the program sponsor and accepting the funding formula and all of the requirements of this program standards unless otherwise provided for it in a collective bargaining agreement. 2. The program sponsor shall notify the department on a current basis with the participating employer and/or shall notify the department any changes in status participating employer. The programs where the program sponsors use participating employment agreements for a copy of the cancellation thereof being furnished in the department and satisfying the requirements of the subsection. H. A funding formula provided by the equitable participation of each participating employer in funding the program, including the equal opportunity pledge and affirmative action, including procedures, dissemination, program openings, and opportunities approved. The selection procedures does not discriminate against individuals' ground, race, or color, religion, national origin, sex, or age. All apprenticeship standards must be contained in articles to comply with the 29 Code Federal Regulations, Part 29 Florida State Rules, Gateway Reference, ASAP number reference 00169, effective December 29, 2008, 1222. The Code Federal Regulations, Part 30 of the Florida State Rules or Gateway /reference, ASAP questionable number reference of 0170, effective March 12, 1978, was incorporated the reference here in hard copy obtained by the contacting Florida Department of Education Division of Career Adult Education Apprenticeship Section 325 West Gainey Street, Room 754, Tallahassee 32399. Rulemaking Authority 446.32, 446.041, 12 Florida State statutes implemented in 446.031 and 446.041, 446.075. Florida State History News ends in June 9th, 1981. Amendments March July 10th, 1983, formerly 38C 1604, amended by the March 29th, 1990, formerly 38C 1604, 38C H 1604, amended by the March 29th, 2011. Rulemaking Authority 446.032, 446.04112, for state implemented 446.031, 446.041, 3141, and 75 for state histories in June 9th, 1981, amended by July 9th, July 10th, 1983, formerly 38C 1604, amended by March, May 29th, 1990, formerly 38C 16004, 38C 16.04, amended 30 March 29th, 2011.